10 second, 5 second, start. Further, the court held that the trial court did not have the jurisdiction to try the cases under the Bombay Rent Act. The appropriate court should have been a small causes court established under the Provincial Small Causes Court Act. Aggrieved by the same, the appellant herein filed this appeal. The counsel for the appellant contended that the impugned order of the High Court erred in appreciating the language of the contract, which clearly points towards the intention of the parties to create a license for continue existing business which was run by the late husband of the appellant. On the other hand, the counsel for the respondent has supported the judgment by stating that there is evidence which shows that the contract entered into between the parties was a license to use the shop, which is covered under Bombay Rent Act. In this light, he supports the impugned order to state that the trial court did not have jurisdiction in the first place. Having heard both the parties at some length at the outset, before we analyze this case, we need to observe some principles on contractual interpretation. Unlike a statutory interpretation, which is even more difficult due to assimilation of individual intention of lawmakers, contractual interpretation depends on the intentions expressed by the parties, and reading out the true meaning is an iterative process for the courts. In any case, the first tool for interpreting whether it be a law or contract is to read the same. It is usual that businessmen often do not sit over nitty-gritty in a contract. In a document, the language used by the parties may have more than one meaning. It is ultimately the responsibility of the courts to decipher the meaning of the words used in a contract, having regards to a meaning reasonable in the line of trade as understood by parties. It may not be out of context to state that the development of rules of contractual interpretation has been gradual and has been placed over centuries. Without going into extensive study of precedents, in short, we may only state that the path and development of law of interpretation has been a progress from a strict formalism to a strict nationalism. It is clear from the reading of the contract that the parties had intended to transfer business from appellant to respondent during the contractual period. This agreement was not meant as a lease or license for the respondent to conduct business. However, the respondent contends that the meaning of the document should not be culled solely with the reference to the language used in the document. Rather, extensive evidence needs to be utilized before adducing proper meaning to the contract. In this regard, he submits that on consideration of all the extensive evidence, the contract should be read as a lease and license agreement which is covered under the Bombay Rent Act. He draws his support from Section 95 of the Indian Evidence Act to state that the document needs to be interpretation having regard to external evidence such as receipts of payment under the contract addressed as rent receipts, etc. It is manifest from these two sections that it is only in cases where the term of the document leave the question in doubt then restore could be had to the proviso. When a document is a straightforward one and presents to difficulty in constructing it, the proviso does not apply. In this regard, we may state that Section 95 only builds on the proviso 6 of Section 92. If the contrary view is adopted as correct, it would render Section 92 of the Evidence Act and also enlarge the ambit of proviso 6 beyond the main section itself.